Before we begin, a quick and important disclaimer. The historical narratives, legal frameworks, and case studies discussed in this video are intended strictly for educational and entertainment purposes. While we delve deeply into the origins of family law and the evolution of legal representation in the United States, nothing presented here constitutes professional legal representation, counsel, or advice. Laws vary significantly by state and have transformed dramatically over the centuries. If you are currently navigating family law matters, it is imperative that you conduct your own due diligence and consult with the licensed, practicing attorney in your jurisdiction. The historical trends and potential outcomes explored in our deep dive reflect past societal norms and do not predict or guarantee any outcomes in contemporary legal proceedings. Let us explore an era when dissolving a marriage did not just involve a trip to the local courthouse, but literally required an act of the state legislature, and in many cases surviving a public trial that would completely destroy your social standing, your financial security, and your very identity. Imagine living in a society where the dissolution of a marriage was considered such a severe affront to the moral fabric of the community that you could not simply hire a lawyer and file standardized paperwork. Instead, you had to petition the highest governing bodies of your state, effectively begging politicians to grant you a personal, localized exemption from a lifelong legal and spiritual contract. If your petition failed, you remained legally bound to your spouse, regardless of the severity of abuse, abandonment, or financial ruin you faced. But what happens when the wealthy, the powerful, and the truly desperate find themselves trapped in this inflexible, unforgiving system? They inevitably find loopholes. And far more importantly, they find the specific men willing to exploit those loopholes for a premium. This is the hidden, often scandalous genesis of what is now a multi-billion-dollar industry. We are going to examine the exact historical moment in American history when a clandestine group of legal practitioners realized there was immense power and unbelievable profit in the business of uncoupling. You might believe the modern divorce industry is uniquely cutthroat, driven by high hourly billing rates and aggressive courtroom theatrics. But the founding fathers of family law operated in an environment with stakes much higher than alimony or standard property division. They were navigating a system where a single legal misstep meant absolute, irreversible social exile. We will examine historical trends that show how early lawyers transitioned from handling quiet, respectable property disputes to engineering highly publicized marital assassinations. Consider the chilling reality of the mid-19th century, where women had essentially no legal identity apart from their husbands under the overarching legal doctrine of coverture. A lawyer representing a wife seeking a legal separation was not just fighting for a fair division of assets. He was attempting to legally resurrect a person who, in the strict eyes of the law, did not even exist as an independent entity. The very first attorneys who specialized in this dark art did not advertise their services in local directories or newspapers. They operated quietly through whisper networks, private gentlemen's clubs, and coded correspondence. They were the original legal crisis managers, tasked with securing legislative divorces, a painstaking process that required them to leverage influence, trade favors, and sometimes coerce state senators and assemblymen to pass private bills dissolving specific individual marriages. We are talking about a time when the dominant legal strategy was not about filing a simple no-fault petition, but about definitively proving egregious moral failing. This required the hiring of private investigators, the cultivation of witnesses, and the orchestration of public scandals so severe and undeniable that the state government felt compelled to intervene. How exactly did we transition from a society that outlawed divorce entirely in certain early colonies to an expansive infrastructure supporting massive law firms dedicated solely to this practice area? There is a critical missing link in the history books, a volatile transitional period filled with shadow dockets, migratory divorce colonies, and the brilliant, ruthless legal minds who built an empire on the ruins of American marriages. The story of the first divorce law firms is not merely a story about statutory evolution. It is a profound story about the commodification of human misery and the birth of a highly specialized, fiercely protected legal cartel. To fully grasp the magnitude of this shift, we must look at the mechanics of early jurisdictional manipulation before we explore what this architectural history means for you today. By the late 19th century, the strict, unforgiving laws of eastern states like New York created an unbearable societal pressure cooker. In New York, the sole legally recognized ground for absolute divorce was adultery. This rigid, unyielding legal framework inadvertently birthed a massive underground economy of staged infidelity. A husband desiring a divorce would hire an attorney, who would then act as the general contractor for a theatrical production. The attorney would hire a specialized private investigator and a woman willing to act as a temporary decoy. The husband would intentionally be caught in a hotel room in his undergarments by the investigator and an impartial witness, thereby providing the exact, irrefutable evidentiary requirements mandated by the court. The lawyer was the grand orchestrator of this perjury, ensuring the paperwork was flawless and the testimonies aligned perfectly. But for those who refused to participate in such sordid, high-risk theater, there was another option, and it laid the ultimate foundation for the specialized, high-volume divorce firm. This was the invention of the divorce mill. Enterprising attorneys realized that certain Western states and territories, desperate for economic stimulation, capital influx, and population growth, had established remarkably lax residency requirements and expansive grounds for divorce, such as the vaguely defined concept of mental cruelty. Ambitious lawyers set up sophisticated referral networks connecting wealthy, unhappy spouses in New York or Boston with local counsel, in places like the Dakota Territory, and later, Nevada. A spouse, typically the wife, would board a cross-country train, establish a brief 90-day residency in a luxury hotel catering specifically to the divorce trade, and hire a specialized local attorney who confidently processed hundreds of these identical cases every single year. These Western attorneys were the true pioneers of the modern, volume-based family law firm. They completely streamlined the required paperwork, standardized the legal arguments, and created a highly efficient, industrialized pipeline for marital dissolution. This was a logistical masterpiece of its time, requiring precise coordination across state lines, intricate knowledge of jurisdictional loopholes, and a highly sophisticated understanding of how to protect immense family fortunes during the transfer of power. This brings us directly to the core of what we are uncovering in this masterclass today. Why does this hidden century-old history matter to you right now in the 21st century? Understanding the raw origins of the American divorce industry provides a crucial, unfiltered lens through which to view the modern legal landscape. The exact tactics pioneered by these early legal fixers, including aggressive forum shopping, the strategic use of public relations to sway judicial opinion, the weaponization of financial discovery, and the meticulous construction of a victim narrative, are the very same foundational strategies utilized by elite family law practitioners today. By deeply studying the historical trends of how early attorneys dismantled the oppressive doctrine of coverture and navigated the chaotic transition from legislative to judicial divorce, you gain profound insight into the structural DNA of the adversarial legal system. We are going straight to the source to deconstruct the architectural blueprint of family law. This series is designed to equip you with a deep, systemic understanding of how modern legal strategies are formulated, how fundamental legal precedents regarding asset division and child custody were historically forged in the intense fires of extreme social stigma, and how the underlying business model of legal representation was permanently altered by the sheer economic demand for marital freedom. Whether you are a student of history, a practicing legal professional, or simply an individual trying to comprehend the complex, often overwhelming machinery of the American judicial system, analyzing these early case studies illuminates the true, unvarnished nature of legal leverage. You will clearly see how the manipulation of jurisdiction and the strategic control of private information became the ultimate, unparalleled currencies in the courtroom. We are deliberately stripping away the sanitized academic versions of legal history to show you the raw reality of how the first specialized attorneys built a permanent industry out of broken vows. You are going to learn how to identify the historical echoes of these early, aggressive tactics in modern jurisprudence, giving you a uniquely analytical perspective on how the law operates not just in theoretical textbooks, but in actual practice when deep human emotions and vast sums of capital violently collide. To understand this massive industrialization of marital dissolution, we must examine the exact moment the legal system buckled under its own weight, forcing the invention of the divorce mill. Imagine if you are a citizen living in New York in the late 19th century. The state legislature had passed an extraordinarily restrictive statute, declaring that the only legally permissible ground for a full divorce was adultery. There was no concept of irreconcilable differences. If you were trapped in a marriage defined by severe financial abuse or physical cruelty, the state of New York formally required you to remain married. You could not simply hire a local attorney to negotiate a separation. This absolute legislative rigidity created a massive, unyielding bottleneck, and where there is extreme legal restriction, there is always immense financial opportunity for those willing to engineer an escape route. Enter the brilliant, highly controversial concept of the migratory divorce. In 1867, The territorial legislature for the Dakota Territory established remarkably lenient residency requirements. If an individual lived within the territory for a mere 90 days, they were granted the legal right to file for divorce under a vast array of newly recognized causes, including the highly subjective grounds of extreme cruelty. When South Dakota achieved statehood in 1889, it retained this precise 90-day requirement. Eastern attorneys instantly recognized this statutory loophole not just as a legal anomaly, but as the foundation for a permanent, scalable business model. They began quietly directing their wealthiest, most desperate clients to board cross-country trains heading straight for Sioux Falls, South Dakota. +1. Sioux Falls rapidly transformed into the first major divorce colony in American history. But navigating this geographical loophole required an entirely new breed of legal representation. The local attorneys in Sioux Falls did not merely file paperwork. They acted as comprehensive lifestyle fixers. Consider the historical case study of Flora Bigelow Dodge, a prominent New York socialite who relocated to Sioux Falls in 1903. Flora could not secure a divorce in her home state, so she traveled over 1,000 miles west. Her legal strategy was not confined to a courtroom. The local residents of Sioux Falls were highly suspicious, and often outright hostile, toward the wealthy Easterners exploiting their judicial system. They would frequently refuse to rent properties or even lease horses to the temporary residents. Therefore, Flora's legal advisors had to orchestrate a sophisticated public relations campaign. She had to actively integrate into the community, joining local civic groups and hosting charity events just to prove her residency was legitimate, and to secure a favorable environment for her eventual hearing. The lawyers in Sioux Falls were managing both the strict judicial timelines and the volatile optics of their clients. They realized that securing a decree required controlling the narrative just as tightly as the evidence. +4. This early framework set the stage for an even more aggressive expansion. As South Dakota eventually faced severe moral backlash and tightened its laws, the geographic epicenter of the divorce industry shifted westward to Nevada. This is where the modern divorce attorney firm truly optimized its marketing and client acquisition strategies. Take the case study of William Schnitzer. He was a New York lawyer who recognized the sheer volume of capital flowing out of the East. In 1907, Schnitzer strategically relocated to Reno, Nevada, and initiated a practice that would shock the traditional legal establishment. He completely shattered the unwritten rules of legal discretion by publishing a detailed pamphlet that openly outlined Nevada's highly favorable divorce procedures. He did not stop at print circulation. He placed advertisements for his legal services in major Eastern newspapers and even projected his advertisements onto the curtains of public theaters. +1. Schnitzer was treating marital dissolution not as a private tragedy, but as a heavily marketed, standardized consumer service. This aggressive commercialization was so historically unprecedented that the Washoe County Bar Association temporarily disbarred him for his entrepreneurial audacity. Yet, his methods permanently altered the trajectory of the industry. These pioneering Reno attorneys created a highly efficient pipeline. They established a system where a client could arrive, reside in a specialized luxury hotel built specifically to cater to the divorce trade, complete the newly reduced 6-week residency requirement, and receive a highly predictable decree, regardless of the complexities of their original separation. The attorneys in Reno relied heavily on the volume of these cases to sustain their practices and, by extension, to significantly fund the local economy. They created a localized monopoly where the hotel owners, the local judges, the private investigators, and the attorneys all operated in a symbiotic financial ecosystem. A spouse would arrive at the train station and be immediately greeted by legal representatives who had already arranged their lodging at a ranch specifically zoned for this purpose. The daily routine of the client was meticulously documented to provide an absolute, airtight case of residency. This was not a chaotic legal scramble. It was a highly refined, step-by-step administrative assembly line designed to process human relationships with industrial efficiency. Why is this specific, localized history critical for a resident of the United States navigating the legal system in 2026? Because the overarching strategies invented in those frontier towns are still the exact mechanisms driving elite legal warfare today. Imagine a high net worth individual, let us call him John, living in an eastern state today. If John anticipates a contentious separation involving complex corporate assets, his modern legal team might advise him to establish a new primary residency in a state with highly favorable property division laws months before any official petition is ever filed. When modern attorneys execute these complex, cross-border jurisdictional shifts, they are running the exact same tactical playbook engineered by those first migratory attorneys over a century ago. The fundamental concept of leveraging geographical jurisdictions against one another to secure a dominant financial outcome was not invented in a modern corporate boardroom. It was forged in the railroad towns of South Dakota and Nevada. These early firms completely industrialized the process of separation. They standardized the legal arguments. They normalized the use of vague grounds like mental cruelty to bypass strict evidentiary requirements. And they established the permanent precedent that wealthy individuals could simply purchase a more favorable judicial outcome by funding a temporary relocation. By studying these historical trends, you strip away the illusion that the family law system is a static, rigid institution. It is, and always has been, a dynamic marketplace where the law bends significantly to those who understand how to manipulate residency, jurisdiction, and procedural timing. The modern law firm, with its specialized departments, dedicated discovery teams, and strategic public relations consultants, is the direct, evolutionary descendant of those frontier attorneys who first realized that geographic boundaries could be weaponized. But this incredibly lucrative, highly industrialized system of migratory divorce could not operate in the shadows forever. The conservative Eastern legal establishment, enraged by the loss of their jurisdictional authority and the blatant public circumvention of their state laws, launched a highly coordinated, vicious counterattack. They began systematically challenging the constitutional validity of these Western decrees, setting the stage for a massive, unprecedented showdown at the highest levels of the federal government. To survive this existential threat to their multi-million-dollar industry, the pioneering divorce attorneys of the West had to invent a defensive legal strategy so radical and so deeply invasive that it would completely rewrite the national rules of evidence and permanently weaponize the concept of personal privacy. Author interview on the divorce colony. This discussion expands on the historical realities of Sioux Falls and provides further context on how the divorce colony shaped modern legal practices. Kelloland Living. Sitting down with the author of The Divorce Colony. YouTube. Kelloland Living 68 views. The extensive historical documentation of this era, frequently discussed by modern legal historians and archival researchers, reveals that the establishment of these early divorce colonies was only the opening salvo in a much larger, far more brutal conflict. The conservative Eastern legal establishment, consisting of powerful judges, entrenched politicians, and traditional law firms in cities like New York and Boston, watched in absolute horror as their jurisdictional authority evaporated. They were not merely losing lucrative clients, they were losing their fundamental grip on the moral and legal order of their society. They viewed the massive outflow of capital and citizens to Nevada and South Dakota as a direct assault on their state sovereignty. Therefore, they launched a highly coordinated, relentless counterattack designed to completely destroy the Western divorce industry. The primary weapon in their arsenal was not a new state law, but a strategic reinterpretation of the United States Constitution itself, specifically the full faith and credit clause found in Article 4. This clause generally requires states to respect the public acts, records, and judicial proceedings of every other state. However, the Eastern legal titans argued that a divorce decree granted to a temporary resident in a Western colony was fundamentally fraudulent and therefore not entitled to any constitutional protection whatsoever. This was not a mere academic debate over constitutional theory. It had terrifying, life-altering consequences for the individuals caught in the crossfire. Imagine the sheer panic of a woman who had spent a fortune traveling to Reno, enduring the highly publicized residency requirement, and securing a legal document severing her ties to an abusive husband. She returns home to New York, believing she is finally free, and perhaps she eventually remarries. The Eastern legal establishment, eager to make a terrifying example of her, would instruct local prosecutors to ignore the Nevada decree completely. Because New York did not recognize the Western divorce, her second marriage was instantly classified as a severe criminal offense. Wives and husbands who believed they had successfully navigated the legal system were suddenly being indicted for bigamy. They faced total social ruin, the immediate confiscation of their property, and lengthy sentences in state penitentiaries. The Eastern strategy was brutally simple but highly effective: criminalize the migratory divorce to entirely destroy the consumer demand for it. If a Nevada decree meant risking a prison sentence in New York, the entire Western legal economy would instantly collapse. To execute this aggressive strategy, Eastern law firms had to conclusively prove that the Western residency was a sham. This requirement triggered the birth of a massive, shadowy industry of private surveillance, deeply integrated into the practice of family law. Eastern attorneys began retaining the services of elite private detective agencies to conduct relentless cross-country espionage operations against their own citizens. These early private investigators did not just follow spouses onto trains. They systematically dismantled their expectation of privacy. They heavily bribed hotel clerks in Sioux Falls to secure guest registries. They intercepted telegrams to prove the spouse was still conducting business in Manhattan, while claiming to live in South Dakota. They monitored bank transactions to demonstrate that the individual's core financial life had never actually moved. The investigators meticulously constructed incredibly detailed dossiers mapping out every single movement, correspondence, and financial transaction of the traveling spouse. This was the exact historical moment when the legal process of separation transformed into a highly invasive, adversarial war of total information awareness. Faced with the imminent destruction of their lucrative enterprise, the pioneering divorce attorneys in the Western colonies had to rapidly evolve their tactics. They could no longer rely on simply renting a room for a client and waiting for the calendar to turn. They had to invent a rigorous, proactive defense strategy to definitively prove the legal concept of domicile, which requires both physical presence and the demonstrable intent to remain indefinitely. The Western attorneys became intense lifestyle managers. They strictly instructed their wealthy clients to purchase local real estate, rather than just leasing hotel suites. They mandated that their clients open substantial accounts at local Western banks, join local civic organizations, register to vote in the territory, and even publicly declare their intention to start businesses in the community. The legal strategy shifted from merely processing paperwork to heavily manufacturing a completely new, legally impenetrable identity for the client. The lawyers in Reno and Sioux Falls spent immense resources creating massive, undeniable paper trails of local integration, essentially burying the Eastern courts under a mountain of contradictory evidence. To understand the profound relevance of this historical warfare, imagine if an individual named Michael, living in the United States in the year 2026, recognizes that his current state of residence has highly unfavorable laws regarding the division of complex digital assets and decentralized cryptocurrency portfolios. Anticipating a hostile separation, Michael quietly relocates to a jurisdiction with incredibly progressive, favorable financial statutes, heavily documented by his modern legal team. When the opposing counsel inevitably challenges the legitimacy of Michael's sudden relocation, the ensuing legal battle is a direct, undeniable reflection of the early constitutional crises over state lines. Today, instead of detectives intercepting paper telegrams, modern legal teams deploy highly specialized forensic data analysts to subpoena mobile device geolocation histories, scrutinize digital login addresses, and heavily audit decentralized blockchain transactions to prove that the relocation is merely a strategic facade. The core historical trend remains absolutely identical: the relentless pursuit of jurisdictional dominance through the aggressive, systematic dismantling of the opposing party's personal privacy. The modern architecture of exhaustive legal discovery was built directly upon the foundation of these early interstate surveillance wars. Despite the meticulous creation of these complex physical and financial paper trails, the Western attorneys realized that fighting a perpetual, defensive war over the exact definition of geographic domicile was incredibly costly and highly unpredictable. The Eastern judges were heavily biased, and the risk of a client being arrested for bigamy upon their return remained a catastrophic liability for the Western firms' reputations. The legal pioneers of the divorce colonies understood that they needed a completely different paradigm. They needed a strategy so overwhelmingly powerful that it would force the opposing spouse back in the East to permanently abandon their legal challenges and voluntarily accept the jurisdiction of the Western courts. They realized that attempting to outlitigate the entire legal establishment of New York or Massachusetts on constitutional grounds was a losing battle. The only way to guarantee the absolute finality of their product was to shift the battleground entirely away from geography and focus it squarely on human vulnerability. The Western attorneys discovered that the ultimate legal leverage was not found in property deeds or voting registrations, but in the highly strategic, calculated threat of absolute public humiliation. If they could not force the Eastern courts to recognize their jurisdiction through constitutional arguments, they would force the opposing spouse to legally submit through sheer psychological terror. To accomplish this, they began to develop a terrifying new legal instrument, a method of documenting and threatening to expose the most deeply hidden, catastrophic moral failings of the resisting spouse to the permanent public record. This strategic pivot required the lawyers to move beyond simple surveillance and dive into the incredibly dark, completely unregulated world of character assassination, setting the stage for the most scandalous, high-profile legal showdowns of the early 20th century. The legal transition from establishing a mere physical domicile to actively weaponizing public humiliation marks the true genesis of the modern adversarial divorce system. When attorneys in places like Reno and Sioux Falls realized that constitutional arguments regarding state lines were incredibly expensive and dangerously unpredictable, they turned to a far more reliable instrument of legal coercion. They deliberately targeted the opposing spouse's societal reputation. During the late 19th and early 20th centuries, family court records were not routinely sealed from public view. Every allegation, every sworn affidavit, and every submitted piece of evidence immediately became a matter of public record the second it was filed with the court clerk. This structural reality existed precisely at the same moment in history when mass circulation newspapers, heavily driven by the sensationalist tactics of yellow journalism, discovered that high society scandals generated unprecedented revenue. The pioneering divorce attorneys recognized this volatile intersection of public records and mass media, and they brilliantly transformed it into the ultimate legal weapon. To force a recalcitrant spouse residing in New York or Boston to recognize a Western divorce, the Western attorneys had to secure what is known as a voluntary appearance. If the Eastern spouse legally acknowledged the Western court's authority, the constitutional vulnerabilities of the migratory divorce instantly vanished. But securing that voluntary submission required immense leverage. Thus, the strategy of the drafted but unfiled complaint was born. A Western attorney representing a fleeing wife would commission a deep, invasive investigation into the Eastern husband's private life. This was not a standard financial audit. This was a deliberate excavation of moral failure. The attorneys cultivated vast networks of paid informants, specifically targeting the household staff of the wealthy elites. Maids, valets, carriage drivers, and private telegraph operators were routinely bribed to provide sworn affidavits detailing alleged infidelities, instances of extreme intoxication, financial improprieties, or intensely private domestic disputes. Once this deeply damaging intelligence was gathered, the attorney would draft a meticulously detailed legal complaint. This document was entirely designed for shock value. It utilized a legal mechanism often called a bill of particulars, which allowed the attorney to list specific dates, times, locations, and explicit descriptions of the opposing spouse's alleged moral depravity. The strategic genius of this maneuver was that the attorney would not immediately file this explosive document with the court. Instead, they would send a private copy via registered courier directly to the opposing spouse's legal counsel in the East. The accompanying message was implicitly clear, representing a brutal ultimatum. The Eastern spouse was given a remarkably short window of time to sign a voluntary appearance and agree to the financial terms of the separation. If they complied, the Western attorney would file a sanitized, completely generic complaint citing basic incompatibility, and the divorce would proceed quietly. If they refused, the attorney promised to formally file the explosive, detailed complaint, immediately alerting their contacts in the sensationalist press. The psychological terror of this tactic cannot be overstated. For a Gilded Age industrialist or a prominent political figure, the publication of such salacious allegations meant absolute social eradication. Bank loans would be called in, corporate boards would demand resignations, and entire family lineages would be permanently disgraced. The lawyers were effectively holding the opposing spouse's entire social identity hostage. They were leveraging the catastrophic potential outcomes of public scandal to force a swift, highly favorable settlement. This completely bypassed the need to argue complex constitutional law before a judge. The true adjudication was happening in private legal offices under the severe threat of journalistic exposure. The early law firms had successfully monetized the fear of the public record, establishing a historical trend where the threat of a trial was far more valuable than the trial itself. To truly comprehend the evolutionary impact of this strategy, imagine if a highly successful corporate executive named Robert, living in the United States in the year 2026, finds himself facing a highly contentious legal separation. His modern legal team might uncover evidence of poorly judged private text messages or questionable, yet legally ambiguous, corporate expense account usage. Following the exact historical blueprint established over a century ago, Robert's attorneys will not immediately rush to a public courtroom. Instead, they will strategically compile this information into a comprehensive settlement demand, heavily implying that a failure to reach a private, non-disclosure-bound agreement will force them to pursue aggressive public litigation, where these private digital communications will inevitably be subpoenaed and entered into the unsealed public record. When modern attorneys utilize the threat of civil discovery as a mechanism to force a quiet, highly structured settlement out of court, they are executing the exact same psychological warfare tactics pioneered by those early Western divorce mills. The medium has simply shifted from bribed parlor maids to forensic data extraction, but the underlying mechanism of weaponized humiliation remains the foundational engine of the settlement process. This relentless commodification of private scandal fundamentally changed the operational structure of the law firm. Attorneys could no longer operate strictly as scholars of legal precedent. They had to become ruthless managers of public relations and crisis communication. They had to build strategic alliances with newspaper editors, frequently trading exclusive tips on upcoming high-profile filings in exchange for favorable framing of their own clients. The law firm expanded from a simple partnership of litigators into a complex intelligence-gathering organization. They retained permanent staff investigators whose sole responsibility was to dig through the refuse of broken marriages, looking for highly leverageable indiscretions. The absolute goal was to ensure the opposing party felt entirely surrounded, facing an asymmetrical threat where fighting back legally meant committing social suicide. However, this aggressive system of legal extortion relied entirely on one fundamental assumption. It assumed that the targeted spouse had something valuable enough to protect that they would eventually surrender to the blackmail. It assumed the fear of public disgrace would always outweigh the desire for legal vindication. But human nature is deeply unpredictable, and eventually, this incredibly fragile system of mutually assured destruction encountered a breaking point. What happens when an attorney sends the explosive draft complaint, threatens absolute ruin in the press, and the opposing spouse completely refuses to back down? What happens when the target is so enraged, so deeply vindictive, or so completely detached from social norms that they welcome the scandal? When the bluff was finally called, these early attorneys were forced to take these highly volatile, salacious allegations out of the private negotiation room and into the actual courtroom, transforming the American judicial system into an unprecedented, completely unhinged theater of moral warfare that would forever alter the legal definition of evidence. When the bluff was finally called, and a targeted spouse refused to sign the voluntary appearance, the massive machinery of private blackmail violently spilled into the public domain. The early divorce attorneys, having failed to secure a quiet settlement, were forced to make good on their threats. This meant taking the meticulously gathered, explosive dossiers of moral failure and entering them into the unsealed public record of an open courtroom. In doing so, they inadvertently created a brand new form of American entertainment and completely redefined the nature of legal evidence. Prior to this era, civil litigation was largely a dry, procedural affair focused on property lines, contract disputes, and complex commercial debts. But the introduction of the contested divorce trial injected raw, unfiltered human drama into the judicial system. The courtroom was rapidly transformed from a solemn hall of jurisprudence into a highly sensationalized theater of moral warfare, with the divorce attorney acting as both lead prosecutor and stage director. To understand the sheer scale of these public spectacles, we must examine the historical trends of Gilded Age legal battles. When elite marriages collapsed and went to trial, it was not merely a local affair. It was national news. Attorneys recognized that to win a highly contested divorce, especially in front of a jury, they had not only to prove their legal case, but also to utterly destroy the opposing party's character in the court of public opinion. This led to a radical shift in evidentiary standards. Lawyers began introducing highly intimate, personal artifacts as formal legal exhibits. Private diaries, deeply personal correspondence, hotel registry books, and even discarded clothing were paraded before the court. The reading of intercepted love letters aloud to a packed gallery became a staple tactic. Attorneys would utilize dramatic pauses, specific vocal inflections, and theatrical pacing to maximize the emotional impact and humiliation of the opposing spouse. The press, seated prominently in the gallery, devoured every salacious detail, printing verbatim transcripts of the testimonies in the next morning's editions. Consider the historical realities faced by the wealthy elites of New York or Chicago during this period. An attorney cross-examining a hostile witness in a divorce proceeding was not just attempting to establish a timeline of events. They were executing a public execution of reputation. They would relentlessly interrogate spouses about their private conversations, their intimate habits, and their deepest insecurities. The strategy was to provoke a public breakdown, forcing the opposing party to lose their composure on the stand, thereby confirming the allegations of instability or cruelty. The law firm had successfully weaponized the judicial process itself. The length of the trial, the volume of the evidence, and the intensity of the cross-examination were all strategically designed to exhaust the opposing party physically, emotionally, and financially until they simply surrendered. Let us place this tactical evolution into a modern perspective. Imagine a high-profile technology founder named Sarah, navigating a bitterly contested separation in the year 2026. Her opposing counsel does not merely rely on financial spreadsheets to argue for a disproportionate share of the marital estate. Instead, mirroring the exact theatrical strategies of the early 20th century, the opposing legal team subpoenas terabytes of Sarah's personal data. They painstakingly reconstruct her deleted text messages, isolate out-of-context voice notes sent during moments of extreme stress, and retrieve private digital calendar entries. When the trial commences, these modern attorneys project these intensely private digital communications onto large screens in the courtroom, reading them aloud with calculated emphasis to paint Sarah as erratic or negligent. This modern deployment of digital forensics is the direct, unadulterated evolutionary descendant of the Gilded Age, attorney reading stolen love letters to a gasping gallery. The core objective remains entirely unchanged: the systematic demolition of personal dignity as a lever for legal victory. The modern family law trial, with its heavy reliance on electronic discovery and psychological profiling, was entirely architected by the men who first realized that absolute humiliation was the most potent form of legal evidence. As these trials became increasingly common, a massive secondary industry erupted to support the courtroom theater. Handwriting experts, early psychologists, and specialized medical professionals were brought in as expert witnesses to testify on matters of mental cruelty, emotional instability, and behavioral deviance. The law firm expanded to include a vast network of these paid experts, effectively creating a cottage industry of professional character assassins validated by scientific or medical credentials. If an attorney needed to prove that a wife's minor eccentricities were actually manifestations of dangerous hysteria, they simply hired the right medical expert to testify to that exact conclusion in open court. This historical trend permanently embedded the use of subjective psychological evaluations into the foundation of family law. The battle was no longer just about who did what. It became a deeply intrusive war over the fundamental mental fitness and moral character of the individuals involved. Furthermore, the media's obsession with these trials inadvertently served as the greatest marketing campaign in the history of the legal profession. As everyday citizens read the daily newspaper accounts of these wealthy industrialists and socialites battling in court, they became intensely educated on the mechanisms of divorce. The public learned about alimony, about the concept of mental cruelty, and about the sheer power of a ruthless attorney. The attorneys who dominated these high-profile cases became national celebrities, their names synonymous with legal terror and immense wealth. They demonstrated to the American public that a marriage was not an unbreakable divine covenant, but a legally binding contract that could be violently dissolved if one had enough capital to hire the right legal mercenary. This constant public exposure shattered the remaining societal taboos surrounding marital separation. By turning the destruction of marriages into a national spectator sport, the pioneering divorce attorneys inadvertently triggered a massive surge in consumer demand for their services from the middle and lower classes. However, as the sheer volume of cases skyrocketed and the courtroom battles grew increasingly brutal and protracted, a catastrophic vulnerability in the system was exposed. The immense cost of funding private investigators, expert witnesses, and months of heavily publicized litigation was rapidly draining the very wealth these attorneys were initially hired to protect. It became painfully apparent that winning a moral victory in court meant absolutely nothing if the marital estate was entirely decimated by legal fees by the time the judge issued the final decree. The attorneys realized they were cannibalizing their own host. To prevent the complete financial exhaustion of their clients, the legal pioneers had to completely revolutionize their approach to the marital estate. They had to shift their focus away from the theatrical destruction of character and pivot toward the complex, highly covert manipulation of capital. They were about to invent a new, devastatingly effective form of financial warfare, a system designed to permanently hide, shelter, and redirect assets long before the first legal complaint was ever filed. The realization that scorched earth public litigation was actively destroying the very wealth it was supposed to divide forced a massive evolutionary leap in the practice of family law. The pioneering divorce attorneys of the early 20th century recognized that fighting over the remnants of a depleted marital estate was a foolish endeavor. To truly serve their wealthiest clients, the industrialists, the railroad magnates, and the banking heirs, these legal architects had to fundamentally shift their battlefield. They moved away from the reactive theater of the courtroom and retreated into the highly proactive, deeply opaque world of financial restructuring. This marked the historical genesis of pre-divorce asset sheltering, a practice where attorneys began to systematically hide, encumber, and redirect vast fortunes months or even years before a formal separation was ever legally initiated. To comprehend the sheer scale of this financial warfare, you must understand the primitive state of economic transparency during the Gilded Age. There were no digitized banking records, no centralized tax databases, and no electronic wire transfers that could be easily subpoenaed. Wealth was highly tangible and often easily concealed through physical stock certificates, bearer bonds, and unrecorded property deeds. The sharpest legal minds recognized this systemic vulnerability and began advising their clients to fundamentally alter their financial architecture, while their marriages still appeared perfectly stable. One of the primary historical trends from this era was the aggressive weaponization of the private trust. Originally designed as a legitimate vehicle for generational wealth transfer and estate planning, the trust was brilliantly repurposed by divorce attorneys as an impenetrable financial fortress. A lawyer representing a wealthy husband anticipating a future separation would meticulously draft a complex trust document. The client would then quietly transfer the bulk of his most lucrative income-producing assets, such as real estate holdings or corporate shares, into this trust. The crucial, devastating legal maneuver was naming a loyal business associate or a heavily compensated third party as the trustee, completely removing the client's direct legal ownership of the assets, while still allowing him to quietly reap the financial benefits through back-channel agreements. When the marriage inevitably collapsed and the wife filed for her rightful share of the estate, she would be confronted with a catastrophic reality. The vast fortune she believed she was entitled to legally belonged to an entity entirely separate from her husband. The courts of that era were structurally unequipped to pierce these sophisticated corporate veils, often leaving the opposing spouse financially ruined despite securing a moral victory in the courtroom. Another highly effective historical tactic engineered by these early legal firms was the strategic deployment of manufactured debt. In an era before standardized credit reporting, a spouse could easily encumber their own assets to artificially deflate their total net worth. An attorney would orchestrate a scenario where the client would sign a legally binding promissory note to a trusted confidant or a shadow holding company, claiming a massive, completely fabricated loan. They would then use the marital property as collateral for this phantom debt. By the time the divorce proceedings reached the financial discovery phase, the marital estate appeared fundamentally insolvent, drowned in liabilities that were legally enforceable, but practically non-existent. The opposing counsel was left fighting over an estate that existed only as a ledger of negative balances. These foundational strategies were not isolated incidents. They were a highly industrialized methodology taught in the private backrooms of elite law firms. They transformed the divorce attorney from a simple litigator into a supreme financial choreographer. To understand the profound, lasting impact of this historical shift, imagine a highly successful commercial real estate developer named William, living in the United States in the year 2026. William senses that his marriage is irrevocably deteriorating. Long before he ever contacts a mediator or discusses a separation with his spouse, he consults with the specialized legal team. Following the exact conceptual framework pioneered over a century ago, William's attorneys advise him to begin a slow, highly sophisticated process of financial distancing. He begins funneling liquid capital into decentralized cryptocurrency wallets that exist outside traditional banking oversight. He establishes complex offshore limited liability companies in jurisdictions with strict corporate secrecy laws, slowly transferring ownership of key developmental properties into these obscure entities. When William's wife finally initiates the separation, her legal team realizes they are not fighting over a readily apparent pool of assets. They are hunting ghosts. This modern scenario is the direct, undeniable descendant of the Gilded Age financial shell game. The modern utilization of offshore tax havens, shell companies, and decentralized digital ledgers to obscure marital assets is simply the technological evolution of hiding bearer bonds in a safety deposit box or transferring railroad stock to a dummy corporation. The overarching historical trend remains perfectly consistent. The party who controls the architectural structure of the capital holds the ultimate leverage in the dissolution of the partnership. This deliberate obscuring of wealth created an absolute nightmare for the judicial system. Judges, who were primarily trained in interpreting statutes and managing courtroom decorum, suddenly found themselves tasked with untangling the most complex corporate financial structures ever devised. They were entirely outmatched by the sophisticated financial engineering deployed by the elite divorce firms. The legal system was practically begging for an intervention, a way to level the playing field and expose these massive financial illusions. The opposing attorneys, representing the spouses who were being systematically starved of their rightful assets, realized that traditional legal arguments were completely useless against a properly executed trust or a manufactured corporate debt. They needed to fight numbers with numbers. This desperate need to uncover hidden capital gave birth to an entirely new, highly specialized professional ecosystem that would permanently merge with the practice of family law. The attorneys realized they could no longer rely solely on private investigators to uncover moral failings. They needed financial mercenaries who could decipher complex ledgers, trace obfuscated capital flows, and definitively prove the existence of shadow assets. This set the stage for an unprecedented escalation in legal warfare, introducing a new breed of professional who would completely dismantle the illusion of financial secrecy and forever change the way money was tracked in the American judicial system. This new breed of professional was the early prototype of the forensic accountant. The opposing attorneys, representing the financially starved spouses, realized that arguing morality against a brick wall of corporate trusts was an exercise in futility. They required a tactical advantage that operated outside the realm of emotion and strictly within the cold, unforgiving realm of mathematics. The traditional private investigator, whose primary skill set involved tailing carriages and bribing hotel clerks for proof of adultery, was suddenly rendered obsolete in the financial phase of the litigation. The law firms began actively recruiting master bookkeepers, seasoned bank auditors, and highly skilled actuaries. These individuals were essentially financial mercenaries, deployed into the legal battlefield with a singular ruthless objective: to painstakingly deconstruct the artificial poverty manufactured by the wealthy spouse. To understand the immense difficulty of their task, you must visualize the Gilded Age financial landscape. There was no centralized software to run a query, no electronic banking network to instantly freeze assets, and no federal tax returns to subpoena, as the income tax did not even exist in its modern form until 1913. These early financial investigators had to operate entirely through manual physical audits. They would secure court orders to seize massive, leather-bound ledgers from the husband's primary businesses. They spent thousands of hours in poorly lit, claustrophobic rooms, manually tracing columns of handwritten numbers. They were hunting for the absolute smallest discrepancies: an unexplained cash withdrawal on a Tuesday, a massive shipment of industrial goods where the revenue was never recorded in the primary ledger, or a sudden massive salary paid to a fictitious employee who happened to share an address with a newly formed trust. They utilized the fundamental rules of double-entry bookkeeping as a weapon. If a massive sum of capital exited the primary business, it had to land somewhere. These auditors were tasked with finding that exact landing spot, no matter how deeply buried it was beneath layers of dummy corporations and proxy associates. When these early financial investigators finally cracked the code, the resulting courtroom confrontations were spectacular. The dynamic of the trial completely shifted. Instead of reading scandalous love letters to the jury, the attorneys were now utilizing giant chalkboards to map out complex corporate shell games. The auditor would take the witness stand and systematically dismantle the wealthy spouse's claims of insolvency. They would trace a specific, heavily documented line of capital from the husband's legitimate steel mill, directly through a manufactured loan, and into the covert trust fund designed to shield the money from the wife. By doing so, they provided the judge with the exact mathematical proof required to pierce the corporate veil. They demonstrated that the debt was fraudulent, the trust was a sham, and the assets were, in fact, marital property subject to division. This completely shattered the wealthy spouse's illusion of control. The legal leverage instantly transferred back to the economically disadvantaged spouse, who could now demand a massive settlement, backed by the irrefutable evidence of financial deceit. This historical trend fundamentally altered the DNA of the divorce firm. The integration of forensic accounting meant that family law was no longer just about the dissolution of a relationship. It was a highly specialized branch of complex commercial litigation. To see exactly how this historical blueprint dictates current legal reality, imagine a scenario occurring in the United States in the year 2026. A man named David is navigating a high-stakes separation from his spouse, a highly successful technology entrepreneur. David suspects that his spouse has spent the last 2 years siphoning millions of dollars from their joint estate. However, when the initial financial disclosures are filed, his spouse appears heavily leveraged and practically insolvent. Because David's modern legal team understands the historical mechanics of asset concealment, they immediately deploy elite forensic accountants. These modern financial mercenaries do not seize physical leather-bound ledgers. Instead, they execute highly sophisticated digital audits. They subpoena cryptocurrency exchange records and utilize advanced blockchain analytics to track decentralized capital flows. They employ data scraping software to cross-reference his spouse's digital footprint with newly registered offshore holding companies in jurisdictions like the Cayman Islands or Nevis. They analyze metadata embedded in digital expense reports to find the hidden second set of books. When David's accountants finally present their findings, they use advanced data visualization software to project the exact flow of hidden capital onto screens in the mediation room, proving beyond any doubt that the spouse's insolvency is a carefully engineered digital illusion. This incredibly aggressive, mathematically driven confrontation is the exact modern equivalent of the Gilded Age auditor standing before a chalkboard. The technology has evolved exponentially, utilizing machine learning and cryptographic tracing, but the underlying strategic imperative remains identical. The side that can definitively prove the hidden flow of capital entirely dictates the terms of the final financial surrender. The introduction of these financial experts triggered an unprecedented arms race within the legal profession. As the auditors became more skilled at finding hidden money, the elite divorce attorneys representing the wealthy spouses simply designed even more convoluted, internationally protected structures to hide it. They began moving capital entirely outside of the United States, utilizing Swiss bank accounts and deeply obscured international trusts, intentionally dragging the opposing counsel into jurisdictional nightmares that could span multiple continents. The cost of waging this type of infinite financial warfare became absolutely astronomical. The legal fees required to fund teams of forensic accountants, international private investigators, and specialized corporate attorneys rapidly consumed the very estates they were fighting over. Discovery periods stretched from months into grueling multi-year sagas of endless subpoenas and depositions. The entire American family court system was rapidly collapsing under the sheer weight of its own adversarial complexity. Judges were completely overwhelmed by dockets entirely clogged with endless motions regarding international asset discovery and deeply contested financial valuations. The public spectacle of destroyed reputations combined with the catastrophic financial burn rates of these trials created an unsustainable societal crisis. The machinery of marital dissolution had become a monster that was actively destroying the families it was supposed to uncouple. Both the legal establishment and the American public realized that fighting perpetual wars over moral fault and hidden capital was mathematically and socially disastrous. The system had reached its absolute breaking point. To survive, the legal architects of the mid-20th century had to execute a complete, radical dismantling of the foundational laws of marriage, paving the way for a revolutionary, highly controversial concept that would strip away the need for private investigators and completely neutralize the courtroom theater. The revolutionary concept that emerged from this era of absolute judicial gridlock was the complete elimination of moral fault as a legal prerequisite for ending a marriage. For over a century, the entire business model of the American divorce attorney was heavily predicated on the absolute necessity of proving that one party had committed a severe, legally recognized offense against the other. The system demanded a victim and a perpetrator. But by the middle of the 20th century, the sheer volume of cases and the immense financial drain of proving these allegations had turned the family court system into a massive hypocritical theater of systemic perjury. Judges, attorneys, and clients all silently participated in an open secret where couples would routinely fabricate instances of extreme cruelty or stage highly orchestrated scenes of adultery, simply to satisfy the statutory requirements of their respective states. The legal architects of the era recognized that forcing citizens to lie under oath just to dissolve a broken partnership was destroying the foundational integrity of the judicial system. The breaking point arrived, and the solution completely inverted the economic structure of family law. This radical transformation officially began in California in 1969 with the passage of the Family Law Act. This legislation introduced a term that would permanently alter the American cultural and legal landscape: irreconcilable differences. By allowing couples to cite irreconcilable differences, The state government formally declared that it was no longer in the business of adjudicating the moral failures of a private relationship. A spouse no longer needed to hire a private investigator to document infidelity, and an attorney no longer needed to publicly humiliate the opposing party in open court to secure a decree. The state simply accepted that the marriage was broken and permitted the dissolution to proceed. This legislative earthquake sent shockwaves through the established legal community. The immediate historical trend was a massive, unprecedented surge in divorce filings. Spouses who had been trapped for decades in deeply unhappy, but not technically abusive marriages suddenly had a clear administrative exit route that did not require enduring a highly publicized trial. However, for the elite divorce law firms, the advent of no-fault divorce represented an existential business crisis. Their traditional revenue streams, which relied heavily on managing complex, multi-year investigations into moral conduct and orchestrating high-stakes courtroom dramas, vanished almost overnight. The highly lucrative alliances between law firms and private detective agencies were instantly severed. To survive this paradigm shift, the early pioneers of the modern family law firm had to execute a brilliant and rapid pivot. They realized that while the law had removed the requirement to fight over morality, it had not removed the requirement to divide the capital. Therefore, the law firms transitioned from operating as moral crusaders and character assassins to functioning as highly sophisticated, administrative asset managers. The battleground permanently shifted from the bedroom back to the boardroom, and the billable hour was no longer spent preparing witnesses for grueling cross-examinations, but rather analyzing complex financial portfolios. To understand the profound operational shift that occurred within these firms, imagine a scenario taking place in the United States in the year 2026. A married couple, Christopher and Emily, decide to end their 10-year marriage. Christopher is a software engineer with unvested stock options, and Emily is a freelance consultant with a fluctuating income and a heavily funded retirement account. Because they live in a modern no-fault jurisdiction, their respective legal teams spend absolutely zero time investigating why the marriage failed. They do not care who was inattentive or who initiated the separation. Instead, Christopher and Emily are instantly into a highly industrialized bureaucratic machinery. Their modern attorneys utilize standardized algorithmic formulas to calculate potential spousal support, deploy specialized forensic actuaries to determine the exact present value of Christopher unvested tech shares, and utilize complex tax modeling to divide Emily retirement accounts without triggering massive federal penalties. This entirely desensitized, mathematically driven process is the direct result of the 1969 pivot. Modern law firms treat the dissolution of a family unit exactly like the unwinding of a complex commercial merger, completely stripping away the emotional narrative to focus entirely on the cold, hard allocation of liabilities and assets. This transition fundamentally changed how law firms scaled their operations. Because the barrier to entry for obtaining a divorce had been drastically lowered, the total volume of potential clients exploded. The industry was democratized. Divorce was no longer exclusively reserved for the ultra-wealthy industrialists who could afford to travel to Reno or fund years of litigation. The middle class was now entering the system by the millions. To handle this unprecedented volume, law firms began operating like assembly lines. They standardized their intake procedures, created specialized departments dedicated solely to drafting boilerplate separation agreements, and hired armies of paralegals to process the massive influx of administrative paperwork. The goal was no longer to win a singular monumental courtroom victory that would make the front page of the newspapers. The new definition of legal success was sheer operational efficiency, processing as many cases as possible through the administrative pipeline, while maximizing the billable hours attached to financial discovery and mandatory mediation sessions. This industrialization of the process completely neutralized the courtroom theater that had defined the Gilded Age. Judges were no longer tasked with determining guilt or innocence. They simply became administrative overseers, ensuring that the standardized formulas for child support and asset division were applied correctly according to the new statutory guidelines. The law firm became a machine designed to categorize, quantify, and liquidate the American family unit with ruthless bureaucratic precision. But while the physical courtroom drama was removed, the psychological warfare simply mutated into a new, far more insidious form. Attorneys quickly discovered that without the threat of public humiliation to force a quick settlement, cases could easily drag on for years in the financial discovery phase. If a spouse wanted to punish their partner under the new no-fault system, they could no longer do it by dragging their name through the press. Instead, they weaponized the administrative process itself. Lawyers began advising their clients to file endless procedural motions, dispute the valuation of every single minor asset, and refuse to agree on the most basic logistical details of co-parenting. The historical trend clearly shows that the adversarial energy of the fault-based system did not disappear. It was merely redirected into a war of financial attrition. The law firms realized that an endless, grinding administrative dispute generated significantly more consistent revenue than a fast, highly publicized trial. The machinery they built to process the middle class was highly efficient, but it was also structurally designed to extract maximum capital through prolonged friction. This created a terrifying new reality for the average citizen entering the legal system, one where the absence of moral fault somehow resulted in an even more devastating financial outcome, setting the stage for the modern crisis of family court reform. The transition from the dramatic, morally charged trials of the fault era to the seemingly sterile, bureaucratic environment of the no-fault system did not actually reduce the animosity between divorcing spouses. It merely fundamentally altered the methodology of the warfare. When you strip away the legal mechanism that allows a wronged spouse to publicly humiliate their partner, that intense desire for vindication does not simply evaporate. It is instead channeled directly into the financial and administrative machinery of the court. The elite law firms, recognizing this enduring psychological need for retribution, engineered a highly profitable system of weaponized procedure. The primary instrument of this new era was not the private investigator uncovering illicit affairs, but rather the billable hour attached to endless, grinding legal discovery. Historically, discovery in family law was a relatively contained process, often relying on simple sworn affidavits and basic banking ledgers. However, as the no-fault era matured, law firms began treating the division of a standard middle-class household with the exact same aggressive, scorched earth tactics previously reserved for complex corporate uncouplings. The strategic objective completely shifted. The goal was no longer to find a smoking gun of financial fraud, but rather to make the very act of compliance so incredibly expensive, exhausting, and paralyzing that the opposing spouse would eventually surrender out of sheer financial starvation. A lawyer would not simply request a list of assets. They would file a massive, multi-hundred-page interrogatory demanding 10 years of highly detailed financial records, complete tax returns, credit card statements, and granular explanations for every single bank transaction over $50. They would issue subpoenas to employers, business partners, and even extended family members. The sheer volume of data requested was intentionally designed to overwhelm the opposing party. If the opposing spouse failed to produce a single document on time, the attorney would immediately file a motion to compel, forcing a hearing, generating more billable hours, and asking the judge to impose financial sanctions. This created a historical trend where the process itself became the punishment. Imagine if a woman named Jessica, a successful small business owner living in the United States in the year 2026, decides to initiate a no-fault separation from her spouse. She assumes that because there was no infidelity or abuse, the process will be a straightforward mathematical division of their joint assets. Instead, her spouse's legal team immediately launches an administrative siege. They demand a forensic valuation of her business, requiring her to hire an independent auditor at her own expense. They subpoena her client lists, her vendor contracts, and her digital communication logs. They file consecutive motions arguing over the exact appraised value of the marital home, the depreciation of their vehicles, and the potential future tax liabilities of their retirement accounts. Jessica realizes very quickly that she is bleeding capital at an unsustainable rate. Her legal fees are compounding monthly, not because she is fighting in a courtroom, but simply because her attorney must review and respond to the endless avalanche of paperwork generated by the opposing counsel. The potential outcomes of this strategy are brutal and highly predictable. Jessica is eventually forced to accept a deeply unfavorable settlement, giving up a disproportionate share of her home equity, simply to stop the absolute hemorrhage of her financial resources. The system successfully extracts maximum capital through prolonged friction. This strategy of financial attrition birthed a massive, highly lucrative secondary economy of professional experts who feed directly off the marital estate. In the modern family court system, attorneys rarely argue asset valuations themselves. Instead, they hire a small army of mercenaries. There are vocational evaluators whose sole job is to interview a non-working spouse and generate a highly speculative report imputing a hypothetical income, which is then used to aggressively drive down spousal support obligations. There are forensic accountants who charge hundreds of dollars an hour to trace digital asset transfers. There are specialized real estate appraisers, actuaries for pension division, and tax strategists. Each of these experts submits a lengthy report, and each report requires a deposition, and each deposition generates more billable hours for the attorneys. The marital estate is essentially treated as a decaying carcass, slowly devoured by the very professionals hired to divide it. But what happens when the financial resources of the middle class are finally exhausted? Yet the adversarial fire still burns. When the capital runs dry, the law firms historically pivot to the only remaining leverage point, the children. The weaponization of child custody became the ultimate defining horror of the modern family court crisis. In the latter half of the 20th century, the historical trend shifted away from the tender years doctrine, which generally presumed that young children belonged with their mother, and moved toward the best interests of the child standard. While this shift was intended to create gender neutrality and fairness, the phrase best interests of the child is legally vague and highly subjective. This vagueness is an absolute goldmine for a law firm, because there is no strict mathematical formula for human parenting. Establishing the best interests of a child requires an immense amount of highly contentious litigation. Attorneys began utilizing custody disputes not necessarily because their client genuinely wanted primary placement of the children, but because the threat of losing custody was the most powerful psychological lever in existence. To argue these cases, the legal system created the incredibly invasive process of the custody evaluation. Instead of a judge making a quick determination, the court appoints a specialized forensic psychologist. This professional conducts exhaustive, multi-month investigations into the lives of the parents. They administer standardized personality tests, conduct extensive psychological profiling, interview the children, observe parenting interactions in the home, and speak with teachers and pediatricians. This process is terrifying, highly subjective, and unbelievably expensive, often costing tens of thousands of dollars paid directly from the marital estate. The parents are subjected to a bizarre, pseudo-scientific trial where every past mistake, every instance of raised voices, and every minor parenting disagreement is meticulously documented and weaponized. A parent who expresses legitimate anger at their spouse might be pathologized in the final report as having poor emotional regulation, directly impacting their access to their own children. The law firms manage this entire process, coaching their clients on exactly how to speak to the evaluators, and preparing brutal cross-examinations to discredit the evaluators if the final report is unfavorable. The custody battle becomes an endless loop of emergency motions, temporary orders, and allegations of parental alienation. The children are effectively transformed into strategic hostages, utilized to force concessions in the financial settlement. The family court system, originally designed to adjudicate discrete disputes, morphed into a sprawling multi-billion-dollar industrial complex that thrives on the perpetual escalation of human conflict. The dockets are completely paralyzed, judges are burned out, and an entire generation of American families has been financially and emotionally decimated by the sheer bureaucratic violence of the no-fault era. The system has become so fundamentally toxic, so incredibly inefficient, and so universally despised that the wealthiest, most powerful citizens in the country realize they could no longer subject themselves to its random cruelty and public exposure. They recognize that playing the game in the public court system, even with the best attorneys, was a losing proposition. To protect their empires, their privacy, and their sanity, the modern elite had to invent something entirely new. They had to completely secede from the American family court system and build a private, shadow justice system where the rules of discovery do not apply, where the public never sees a single document, and where the final decree is bought and paid for in absolute secrecy. The evolution of the family law firm ultimately culminated in the creation of an entirely parallel legal universe. To truly comprehend the sheer magnitude of this final architectural shift, you must understand the exact mechanisms of the modern shadow docket. The elite legal minds representing the ultra-wealthy recognize that the public family court system, with its endless delays, backlogged schedules, and unsealed public filings, had become an unacceptable liability. When a multi-billion-dollar marital estate is dissolved in a public forum, the required financial disclosures inevitably expose proprietary corporate structures, highly sensitive investment strategies, and the fundamental vulnerabilities of massive holding companies to business competitors and the press. The solution was to effectively privatize the judicial process. This led to the explosive growth of what is legally known as private arbitration, but what is practically understood as the rent-a-judge system. In this completely insulated ecosystem, couples bypass the public courthouse entirely. Instead, their law firms legally retain the services of a highly experienced, retired family court judge. This private adjudicator is paid an exorbitant hourly rate, often exceeding $1,000 an hour, to hear the case, review the financial discovery, and issue binding rulings in absolute, legally protected secrecy. Imagine if a high-profile venture capitalist named Marcus, living in the United States in the year 2026, decides that his marriage is irreparably broken. Marcus controls vast portfolios of decentralized digital assets, complex international real estate trusts, and highly sensitive corporate board seats. His modern legal team knows that subjecting his financial life to a standard public discovery process would be corporate suicide. Therefore, long before any paperwork is ever filed with a county clerk, his attorneys approach his spouse's legal counsel with an incredibly lucrative, non-negotiable proposition. They offer to fund the entire dissolution process through private arbitration, provided that every single individual involved signs an ironclad non-disclosure agreement. This agreement includes catastrophic liquidated damages clauses, meaning that if the spouse, any attorney, or any forensic accountant leaks a single detail to the public, they are immediately penalized by millions of dollars. The proceedings do not take place in a municipal building. They occur in the highly secured, soundproof conference rooms of elite corporate law firms. The private judge issues a binding ruling dividing the assets, and the only document ever filed with the actual public court system is a single, sanitized sheet of paper stating that the marriage has been dissolved, with absolutely zero details regarding the division of capital or the custody of children. This represents the ultimate, ironic conclusion to the historical timeline of the American divorce industry. Over a century ago, the pioneering attorneys in Sioux Falls and Reno built their entire business model on the aggressive weaponization of public scandal. They utilized the intense fear of the public record to force wealthy individuals into submission, reading stolen diaries aloud to a packed gallery, and inviting the sensationalist press to document the moral destruction of the opposing party. Today, the most elite family law firms sell the exact opposite commodity. They sell absolute invisibility. The ultimate luxury in the modern legal landscape is the complete erasure of the public record. The modern attorney is no longer a stage director managing a highly visible theatrical production. They are a covert operative constructing an impenetrable fortress of legal confidentiality. They have successfully commodified privacy, turning the fundamental right to a public trial into a primitive relic of the past, strictly reserved for those who cannot afford to buy their way out of the system. This historical evolution has created a deeply entrenched, profoundly divided two-tiered system of justice in the United States. On one side, you have the massive, grinding administrative machinery of the public family court system. This is where the middle class is continuously processed, their modest assets slowly drained by the endless procedural friction, the weaponized custody evaluations, and the brutal war of financial attrition we explored earlier. They are trapped in a deeply underfunded system where judges have mere minutes to review complex cases, and where the adversarial process inevitably destroys the very families it is attempting to untangle. On the completely opposite side, operating in the shadows, is the bespoke, highly efficient private justice system. Here, billionaires and massive corporate executives experience a completely frictionless uncoupling. Their assets are shielded, their reputations are entirely protected, and their legal disputes are resolved with the exact same clinical efficiency as a high-level corporate merger. The law firms orchestrating these private divorces have achieved the absolute pinnacle of legal engineering. They have completely removed the chaos of human emotion and the unpredictability of the public from the equation, replacing it with a heavily controlled, privately funded administrative machine. By deeply analyzing these historical trends, from the early days of legislative divorce where citizens had to beg politicians for freedom, to the massive interstate surveillance wars over jurisdiction, to the modern deployment of elite forensic accounting and invisible arbitration, you gain a profound understanding of how the legal system truly operates. The law is not a static set of rules. It is a highly malleable, heavily weaponized instrument that constantly evolves to protect massive concentrations of capital. The attorneys who shaped this industry were not merely practicing law. They were fundamentally rewriting the societal architecture of the American family. They transformed marriage from a lifelong spiritual covenant into a complex financial contract, and they built a multi-billion-dollar industry on the inevitable dissolution of that contract. They proved, decade after decade, that whoever controls the jurisdiction, whoever controls the flow of information, and whoever controls the financial architecture ultimately dictates the terms of human freedom. But as the system of private arbitration reaches its absolute zenith, completely insulated behind walls of corporate secrecy, a massive new vulnerability is rapidly emerging. What happens when the highly encrypted, heavily guarded digital ledgers holding the secrets of the shadow docket are breached, and the most powerful individuals in the country realize that in the modern era of decentralized data, absolute privacy is simply an illusion waiting to be shattered? We will explore the terrifying collapse of digital confidentiality and the emergence of the next generation of legal warfare in our upcoming bonus investigation.